Welcome to JD Supra's latest corporate law report. This week we're focused on workplace issues with the latest need-to-know updates and advisories from some of our leading employment law firms. Here goes. First up, a look at law firm Littler Mendelson's excellent 80-page report on the most challenging issues facing global employers today. For multinational employers, hiring, firing, managing, and supporting employees becomes even more complicated when you consider how many global jurisdictions are involved. Littler's report addresses many of these complications by focusing on critical topics like sustainable innovation, workplace harassment, building a global HR team, anti-corruption compliance, and other issues on a global scale. The report also looks at the unique challenges of doing business in Latin America, China, and other parts of Asia. One takeaway from the section on forging a global HR team: understand the local culture. While companies try to think and act globally, in reality, operations take place locally. You won't succeed unless you take into account the influence of local culture. It is a terrific resource filled with well-researched information and rich takeaways for all global employers. You can read Littler's report in full below. What else in employment law news? Here's a quick look at 3 need-to-know updates. A word on textual harassment from Kristen LaRosa at Pepper Hamilton. If you give your employees electronic devices, either have a clear policy requiring that they are used for work purposes only, or create a policy clearly stating what constitutes acceptable personal use. Spell out what's not permitted, including harassing text messages. A word on working interviews from Michael Kelsheimer at Looper Reed. If you bring in somebody to work for a day or two to see if they're actually good to hire for the job, you must pay them no matter how short or long the test run. Also consider creating a day or week-long contract, depending on how long you plan to evaluate your candidate. And from Peter Felsenfeld at Barger-Wolin, a reminder that employers can run the risk of violating federal labor laws when monitoring employees' union activities. Union monitoring by employers can be seen as coercive depending on the length of observation and depending on an employer's distance from employees while observing them, among other factors. Read the full analysis based on a recent NLRB decision to do with employee union activities at Allied Medical Transport below. The final word this week goes to attorneys Kevin Hogan and Nancy Campbell of law firm Snell and Wilmer. The Supreme Court is expected to rule in June of this year on 2 key same-sex marriage cases, the Defense of Marriage Act and California's Proposition 8, both of which will have an impact on employee benefits programs. Employers should be prepared to respond based on the court's final decisions. If the Supreme Court overturns both cases, in effect ruling that same-sex marriage is not legal, very little will change in terms of employee benefits. However, if states are allowed to define what constitutes a legal marriage, or if the court rules favorably for same-sex marriage across the board, it will mean major changes for employee benefit plans, including health plan coverage, FMLA leave allowances, retirement plans, and other such benefits. You can read more about the impending Supreme Court decision and what it means in the workplace below. You know where to find the updates that inform this week's corporate law report. Until next time, we'll see you online and on JD Supra.